IC Golak Nath and others versus State of Punjab and another. This is a landmark judgment by Supreme Court which was decided by 11 judges bench of the Supreme Court in 1967. In this case, the constitutionality of the Constitution, 1st, 4th and 17th Amendment Act was challenged on the ground that the fundamental rights conferred by Part 3 are inviolable and immune from amendment. It was said that Article 368 does not give any power of amendment, and in any event, the amending power is limited expressly by Article 13, Clause 2, and impliedly by the language of Article 368 and other articles as also the preamble. It was then said that the power of amendment is abused and should be subject to restriction. The acts are attacked also on the ground that they made changes in Articles 226 and 245, and such changes could not be made without complying with the proviso of Article 368. In this case, the judgment was as a majority-minority judgment, and as the bench was 16 judges bench, so it was decided in the favor of 6-5, and the final verdict was like fundamental rights part of the Indian Constitution is fundamental and inviolable. So what court held was that the fundamental rights are outside the amendatory process if the amendment seeks to abridge or take away any of the rights. That the 1st, 4th and 7th amendments, being part of the Constitution by acquiescence for a long time, cannot be challenged, and they contain authority for the 17th amendment. That Supreme Court, having now laid down that fundamental rights cannot be abridged or taken away by the exercise of amendatory process in Article 368, any further inroad into these rights as they exist today will be illegal and unconstitutional unless it complies with the Part 3 in general and Article 13 Clause 2 in particular. That the abridging or taking away fundamental rights, a constituent body will have to be invoked.